Welcome to Counsel Culture, the Business of Law podcast brought to you by Byfield. Welcome back to Counsel Culture, the Business of Law podcast. This week, as per the end of every month, is the litigation and investigations crew that's back on the podcast. Hello, Dina. Hello, Gus. How are you both?
Good, thank you. Very happy to be back on. It's been a while, but nice to be back.
It's been a while. It's been a busy summer for us. So yeah, we took a break, but we're back now.
We're back. Hi, Meg. Hi, Dina. I'm really pleased. This is, I think, the first podcast we're recording from our new offices.
Correct.
And it's a bit surreal for me because I'm back in this office 20 years after I was here for about 2.5 years with a firm called Russell Jones and Walker. And it's good to be back in 80 to 86 Gray's Inn Road, and really good to be back on the podcast, recording our first disputes podcast from our new office.
Yeah, it's a lovely space, and we just moved in this week, so yeah, it's been really exciting. But let's discuss. Today we're talking all about ESG kind of litigation. So I think we're just going to start off with a quick case, obviously the BHP case. So over the summer, really quickly, so BHP announced that it entered into an agreement with Vale SA in relation to group action proceedings in the UK regarding the Fundão Dam failure in Brazil. And as per the agreement, BHP and Vale will have to pay 50% of any amounts potentially payable to the claimants in the English proceedings, in the Netherlands proceedings, and other proceedings in Brazil covered by the agreement, without any admission of liability for those. So that's where we're at. There's a 10 or 12 week trial coming up in regards to liability. Dina, do you want to start? Do you want to talk about it a bit more?
Sure, I can. Thanks, Meg. Yeah, you mentioned the developments over the summer. I think we're now all looking ahead to October. In a few weeks' time, there's going to be the trial, as you mentioned, which will determine the liability. It's a key juncture of this case. I think, everybody's going to be looking. The numbers are so big that everybody's taking an interest in this. I think there's lots of things that have been happening with that case since it started. Thinking right back to the book building process, as it was an opt-in, getting over 700,000 people signed up. I think I understood that there's significant operations on the ground in Brazil, speaking to the people on the ground who've been affected there by the tragic accident that happened. As we move into the liability trial, there's lots of considerations around how that is going to play out, including, I suppose, from a reputational perspective too, thinking about the media coverage that is happening in the lead up to it. We saw the ITV reporting most recently, just yesterday, I believe, on the ground in Brazil, as we build up into that trial, and then throughout the trial as well. It's going to attract significant media attention. There's such a human interest element to this story, and people are following it so closely. And then also thinking about post-trial as well. The outcome of that trial will obviously have a significant bearing on the reputation impact for everybody involved on both the claimant and defendant side. But yeah, it's really all eyes on that, I think, at the moment. It's a big decision coming up.
Yeah, and it's been running for a few years. It will run into the next at least 3 to 4 years, potentially more. Gus, any thoughts?
Yeah, just to put the context then, this was the Fundão Dam, which is been characterized called the Mariana Dam as well, collapsed in 2015, a catastrophe, decimated village and local community, and the claim is that it was unsafe. There has been reparation in Brazil, and this is part of the legal argument that through the Renova Foundation that BHP, Samarco and Vale have made good on some of the significant damage that was caused, and that this claim should therefore continue to be dealt with in Brazil. Now BHP is a UK listed entity, and therefore the argument is that the claim should be heard here. So from a media spotlight perspective and attention on BHP, you've now got this 10-week trial that's coming up very soon, and there will be a huge amount of media reporting around it. And as Dina said, the human interest elements around the claim and the way it's being portrayed of a case of putting profit before safety, and therefore people's lives being what many people think 19 people died and many lives have been ruined as a consequence. It cannot escape the public consciousness. So in terms of the defence of liability and whether BHP are responsible for this, it will be a very emotive set of weeks and months ahead.
Yeah.
In terms of the longevity of it as well, if this does go to trial, I think they're saying that the trial will happen in 2027 or 2026 or 2027. So again, you've got a very, very long tail to a full trial. And then I think it's listed for 22 weeks. So it's a huge amount of time for...
It's like 4 or 5 months?
4 or 5 month trial. And the reporting that will go on with court reporters in that time.
Yeah.
And the arguments being put out by both sides and the narratives from both sides is going to be really, really important here, because obviously from the claimant perspective, it is all about that personal loss.
Yeah.
From BHP's perspective, it's about liability and the good that they've already said that has been made in relation to reparation and what's been going on in Brazil. But from a public consciousness perspective, the issues at play here are very, very significant. So the reputational impact to BHP is equally significant. And it's going to be very interesting to see how the company responds through the court proceedings, these initial court proceedings. If liability is established and it goes to a full trial, the complexity then of having to potentially pay out damages to a class of 700,000 claimants on an individual basis is also really, really significant in terms of how long that takes.
Yeah.
And again, the communications around all of that.
Just,
And I think, oh, sorry, go ahead, Dina.
Sorry, I was just going to add to a point you made, Gus, there on from the claimant perspective, it being all about personal loss. I think there's also the messaging and the narrative around corporate accountability, which we know is a hot topic at the moment, especially with ESG activism and holding corporates to account through the use of the courts. So I think, BHP also have to think about how they address the accountability, the points, which I know they are doing some work through the foundations, as you mentioned, Gus. But I think that they've got a bit of a hill to climb, really, with dealing with that in the media when you add all of the personal interest elements to the story as well.
For sure. And I think, just handling stakeholders across jurisdictions. And obviously, if this trial doesn't go their way in October, how is that going to impact the other trial in the Netherlands, etc.? So I think it's a big deal for sure for everyone involved. But yeah, I think it's particularly difficult to manage for the defendants in the case. Go ahead. Yeah.
I was just going to add one final point there to what Dina said about corporate accountability, and this is about there is, I think the amount that's being reported is 36 billion in damages being claimed by the claimant group, but there's also this very strong message that this isn't just about the compensation, it's about the accountability. And that's where the liability point and the whole narrative around that is going to be really, really important, and how that plays out in relation to how the claimants and the claimant law firm representing them characterises that argument through the media, and how BHP counters the accountability and liability point, and whatever happens after this 10-week trial will have a significant impact in how that continues to play out.
I think, Gus, that's really that point that we often talk to clients about in terms of how you respond to a story, maybe not of this magnitude, but where you're in that tricky position as responding as a corporate. So from a business perspective, from the commercial perspective, appeasing your key stakeholders, which are often your shareholders, and then also responding to the issues at play, which may have a really significant human interest element, and almost from a consumer perspective, and striking that right balance of being in the middle of those two, which is a really, really hard place to be in, I think, as a corporate. So for BHP to address the liability points that they're going to have to face, and we all know that they're robustly defending, whilst also addressing the human interest points, I think puts them in that really tricky place. So it'll be really interesting to see how they come out publicly during the trial as well.
And moving on to kind of a wider kind of discussion around how these cases are brought. I think this one was a GLO in the High Court, but obviously a lot of the kind of group litigation in the UK goes through the CAT. A question around that is, what do you think is the right forum for these types of actions? Is there one better than the other?
It really depends on the kind of claim that's being brought, and there's an interesting argument right now that there is an ESG, there's an environmental claim going through the CAT. Indeed, I think it's today that the hearing ended, 3-day hearing on whether that should proceed to a full trial, and that's the 700 million claim being brought against 7 water companies, I think. Yeah. And it's a competition claim because it's argued that they underreported the pollution incidents that they have to report, which had a negative impact on the consumers because they're a monopoly. The important thing there is because that then goes into the CAT, it's an opt-out claim. So the millions and millions of consumers are already in the claim, and it becomes much easier to manage that class. You still need a lot of communication around the action itself. But conversely, if you're bringing a claim, an ESG a claim in through a group litigation order, that tends to be an opt-in, where you have to sign up individuals to be in that claim, and that's a longer process. And from a communications perspective, it's actually a book build PR exercise, as we call it, and that means going out to the right kinds of publications, a lot of media relations, really, really important. Advertising, social media campaigns to sign those people up. But we also seeing representative bodies bringing these claims, like the Good Earth Project, the Good Law Project, environmental campaign groups, NGOs, and we're going to see more and more of those.
Yeah, actually on that, so obviously Climate Earth has tried a couple of times, I think, to kind of hold a few companies to account, especially in regards to ESG. I think the consensus is we're indeed expecting more of these types of claims to come through, especially from these charities and organizations. But how is that going to evolve, Dina? What do you think?
Well, I think you've kind of said it there, Megan, that we're definitely expecting more of this type of litigation. I think there's debates and arguments over how successful that is, because there's been limited success in the court so far. But I think you get into the wider questions really around the purpose of that litigation, and whether that just by bringing it brings it onto the public agenda, so serves its purpose in that way. So I think we're definitely going to see more of it. I think there's also the question around whether it's the right forum to bring that litigation. And I think you could probably argue, or at least try to argue, that the lack of success so far is actually just because it's a novel use of law, and it's a novel way of bringing this stuff onto the corporate agenda. So I think it's probably a matter of time before we see one of these types of claims have some success. And then obviously you get back to the point around what the measure of success is, and whether it is succeeding in the courts and securing damages or something like that, or whether it's bringing it sufficiently far onto the consciousness of these corporates that are being held to account through the litigation, that is enough for these organizations.
I think there's a study out there by the London School of Economics which shows that globally ESG environmental claims are massively on the increase.
Yeah.
I think there's been a 23% increase just in the last year. If we're looking at the UK, there have been actually a number of successful challenges against governments and local governments relating to climate change commitments, which were globally agreed in I think 2015 at the Paris Accord. The goalposts have changed, and governments, local governments, national governments have pulled back on those commitments for various reasons. And so there have been challenges against reneging on those. So we have had some successful claims against governments in the UK and local governments, not against corporations yet. I do think one interesting area to look at, though, is the claims for ESG brought under the Financial Services and Markets Act and Section 90 of that. And again, this is a developing area. It's usually brought on an opt-in basis, and I think we will see some developments around this in relation specifically to ESG, because historically, you could bring a Section 90 claim where a company made misleading statements around its financial performance or financial conduct. That has now been expanded into other areas of corporate governance, including pronouncements made in relation to greenwashing, pronouncements made in relation to commitments to the environment. And if that is deemed to be damaging of the company, we are going, by shareholders, we will start to see more and more shareholder claims against those companies brought by shareholders. This is a broader development we're seeing in relation to securities litigation. Again, a really hot topic and an area of development in relation to litigation and litigation PR. And we're already seeing this. I think there's a claim against Boohoo in relation to its supply chain. There are other claims out there for human rights abuses in relation to supply chain. And again, these are the kinds of claims that capture the public consciousness. And in terms of going back to the book build and the opt-in procedure, getting to those shareholders, institutional investors, from a PR perspective, it's all about raising awareness of those claims. And the reason why, as a shareholder, you should participate in that claim through the best means of getting to those. So it's usually the financial press, the investment press, pension funds get involved in a lot of these claims. You've got the UK superannuation scheme. So it's an area that I think we're going to see developing securities class actions a lot more across Europe. But also, you talked about novel uses of bringing actions. Dina, I think we're going to see more and more of it in relation to ESG claims. And when we talk about ESG, we for some reason we all tend to think about environment first, but the governance aspect of ESG is really important, and that's where I think we'll see a lot more of these types of claims.
I think also within that, if you just look at what we've been talking about for the last few minutes, what we're effectively talking about is issues, social issues, ESG issues being high on the agenda, and people finding the mechanisms to hold people to account, whether that's the public or whether that's shareholders. And so what you're, I think, increasingly going to see when we talk about how this is going to evolve is the intersection of the law, public affairs, lobbying, policy, and kind of public sentiment. And you're going to need campaigns that address all of those things, whether that's on the claimant side to create the change that you're trying to create, or on the defendant side, you're going to need to address all your stakeholders through marrying up all of those different components. So increasingly interrelated at an issues level, and also how you deal with them, I think.
And just to make a point there in relation to how do corporates respond to this, well, I think we all there was a rush to talk about our ESG credentials post 2015, post the Paris Accord, and because we want to be better corporate citizens. But I think there is a word of warning here that companies need to be really, really careful about any public statement they put out there, not going too far, because it will be pounced upon.
Absolutely, definitely. And I think also, for a lot of these, it's funny because actually a lot of these companies quite often jump on the bandwagon for whenever they want to look kind of good and stuff. But like we're seeing it even in our own industry, a lot of firms, 3 years ago we're like coming out with these claims of like, oh, we're going to have 25% of our, partnership that's going to be, female, whatever. And then it's like, well, by 2025 or something, and it's like, well, by that point, you're people will be tracking this and holding you accountable. And I think that's the same for a lot of these companies that like, make promises to the public around, we're going to do everything we can to make sure that we go to like, we use like more environmentally friendly things or whatever it is. And, like the fashion brands that you mentioned earlier, I don't think it came as a shock to anyone that there were issues around allegations of like mistreatment of slavery in their supply chains and their factories and whatnot. And I think this is like, I think especially for consumer brands like that, it's so like it could potentially be like a nail in the coffin, more than for like funds and whatnot and like more professional and financial services and bigger companies. I think for these types of like directly linked to the consumer.
Do you think, Meg, that's because the consumer who buys those products cares more about these issues?
I think so.
Yeah.
I think so. I think we've got a generation, like people who shop at Boohoo and whatnot, they're a certain age, and I think a lot of them care more and more about these issues and become more and more educated about it. And while they're not going to be the ones bringing the claims, they'll be the ones educating themselves and thinking, you know what, like actually I'm going to boycott this because this came out in the press or, whatever. And I can't do that anymore. I mean, we are seeing a lot of brand boycotts at the moment for other reasons, but it is really powerful. We are seeing the impact on kind of these companies' financial results and just their reputation overall worldwide. And it really is really dramatic compared to like, an ESG claim against BP. Do you know what I mean? It would be like, okay, well, people will still need whatever the product they provide. So it's kind of, you kind of need that. Whereas Boohoo, you don't necessarily need to buy their clothes because there's so many others out there that you can go for that might be more environmentally friendly or whatever. So
I think it's really interesting. And do you both think that that kind of pressure from the end consumer can then have an impact on shareholder activism as well?
Absolutely, because if you've got a significant boycott against your company, well, the material and commercial impact on that is significant. And therefore, you get into the shareholder activism space of the way that they can hold their investments to account is through litigation. So I think absolutely, yeah, I think you can mobilize shareholders in that way.
And it's not expensive necessarily to buy shares as well. Like, anyone could buy them and then all of a sudden just decide to launch a claim. It would be so like not necessarily too easy, but still kind of doable for a lot of people. And if you're passionate enough as a consumer, it's not unrealistic to think that that would happen quite often.
And we're going to see more of these claims, aren't we? I mean, I think that's fact. And when we look at ESG, it covers such a broad gamut of different areas and concerns: consumer concerns, corporate concerns, political concerns, societal concerns. If you are a company on the receiving end of more and more of these claims, what kind of advice are we giving them from a good corporate communications reputation protection perspective?
I think the communication comes from the top. So thinking about how your corporate communications aligns with your actual actions, it's got to be real. The more you fabricate it, or the more distance there is between what you're saying and what you're doing, the harder it is to mitigate the claims that are being made against you. And it's a relatively obvious point, but I think often corporates overlook that and think that they can get away with saying things with not much evidence to substantiate it, maybe just one or two points. So I think key thing is what's the saying? Speak what you do, or something like that. But some, actually,
I forget as well.
Pardon?
I forget as well what they're saying.
I actually forget as well. So I think we'll edit that bit out.
Maybe it's not a saying at all, and it's just
no. It is. It is. Speak what you. Yeah. It is. It is.
Practice what you preach. That's it.
Practice what you preach.
There we go. Practice what you preach. It came to me in the end. But I think it's an obvious point. But I think the more corporates ingrain that in the way that they operate, the better. And obviously, there's always a balance between marrying kind of what you're doing versus protecting the bottom line. But how far do you go in protecting the bottom line if you end up with a boycott against your company in the end? So practice what you preach, and then if an issue like this does arise, then I would say what can you do that quickly mitigates that? And that's not, I don't mean immediately respond, but how can you put plans in place, at least show that you've listened to the concerns that have been raised, and you're addressing it steadily, and in a controlled and proper way, to try and make those consumers feel and aware that you're kind of addressing it and are equally concerned by it. And if they've already gone, over time, think about how you win them back.
I think for a lot of companies that end up in those situations, they start caring about the comms at the point where it's too late, where the litigation threat is already there. They've been served with something, and at that point they kind of panic and do their comms. And I think actually a lot of these, especially the consumer brands, but I think every company should already be thinking about actually prep for potential issues, because I'm sorry, some of these brands actually do know what's going on and what they're doing, and that there is a risk that some of that stuff will come out at some point. And so on the off chance that it does, you should just prep your comms early, just to have an idea of how you would respond if there was a situation like this, or whether you'd respond at all. So it's kind of asking yourselves those questions and just making sure that, obviously you're compliant with the regulations and the law of each jurisdiction. But I think if there were failures, that you know about them and that you really prepped for, this might never come out, but actually it might. And if it does, how do we handle it? So I think it starts there, because I think at the point where you're in litigation, you have to do the comms anyway as you go along. But actually, I think a lot of them start engaging professionals like us when it's already started.
I completely agree, Meg, and I think you can never be overly prepared for a crisis. And good crisis planning includes litigation events as well. And if we go back to BHP, this claim is a very, very long running claim. The reputational bleed from this one claim into the wider company, and we're talking about a huge entity here, it's about trying to isolate that issue as much as possible from the wider company and what you're doing, but ensuring that the measures are in place to communicate properly and in a timely fashion for when the issue does hit. But also, if there is a regulatory finding, or indeed you lose a claim, or some liability is found, it's about how you respond to that event in direct response to it, whilst also continuing the business as usual corporate communications and promotion of all the other good work you're doing. Because over the life cycle of a large company, you are going to face litigation. And it's how you prepare for it, how you respond, how you make good on any findings, whether a regulatory finding or a legal judgment against you, and ensure that you continue then to act as a good corporate citizen in line with your values. Going back to what Dina says, practice what you preach, and try to ensure as far as possible that you continue to operate within those parameters.
Great. Well, thank you both. I think that's the end of the episode. It was lovely to have you back on. And to everyone, we'll be back next week for another episode. And you can find us on Spotify and Apple Podcasts. And we wish you all a good weekend.
Thank you, Meg.
Thanks, Meg.
You've been listening to Counsel Culture, the Business of Law podcast brought to you by Byfield. Thanks for listening. Don't forget to subscribe and join us again next week, where we'll be discussing some more of the biggest stories in the legal sector.